All right, welcome back. We had a doozy yesterday where we went over Delete Law's Second Amended Complaint in DeCastro versus the Las Vegas Metropolitan Police Department. And today we've got the follow-up. We've got the motion to dismiss that Second Amended Complaint. But first, for those of you who are new, go, we're way into this, so go watch the previous videos. Yeah. But also, I'm Joe. Hi, I'm an attorney licensed to practice in Utah. This case is in Nevada, obviously, although there is a Las Vegas, New Mexico, and I'm sure there's one or two others. But either way, so as usual, first place we go is the docket. And we scroll, and we've got 70 things in the docket now. But like I said, so we had the Second Amended Complaint filed November 27th, and the motion to dismiss was filed a week early in what was a galaxy brain move by Craig Anderson. I absolutely love that he filed this a week early because he filed it December 11th. Now, you'll notice highlighting here in very small text, so I'll read it to you. Response due on Christmas. So by filing a week early, the motion to dismiss, Craig Anderson played Delete Laws. And so Delete Laws is going to be furiously chat GPTing on Christmas Eve and probably on Christmas as well, trying to get it ready by end of day Christmas. That is brilliant. I absolutely love it. And what I love even more, so Delete Laws threw his hissy fit when the judge dismissed most of his First Amended complaint. So he tried to get the judge recused. The judge said, nah, bro, I'm good. So Delete Laws filed a motion to reconsider. And the judge is once again going to say, nah, bro, I'm good. But in filing their response on December 18th, we know Delete Laws must have the last word. Whether a reply is needed or not, he's going to do one because he must have the last word. So his reply is due, once again, for those of you who can't see, because I realize the docket is small, but it's also due on Christmas. I like to think that this was Craig Anderson saying, Merry Christmas, bitch. So I like that. I really like that and just wanted to point it out. And one final thing before we jump into the documents, I got an early Christmas present today. Shocking, I know. But we have a new lawsuit to cover. So I'm not going to give too much away, but for those of you who follow Marky, a fellow YouTuber who I had never heard of until he was mentioned in the Scofield versus Guillard lawsuit. He's been covering this situation, but he hasn't made a video about the lawsuit yet, just about the things leading up to it. But for those of you who follow Marky and Runkle of the Bailey, because he actually has made a video about the complaint, but we'll be following that. And I like to think, for those of you who have wondered, what would it look like if Delete Laws was a licensed attorney? So you're going to want to stay, to tune in when I do go over that new complaint in the new lawsuit, because I believe that has the answer to what delete laws as a licensed attorney would look like. Scary, I know, but I have a feeling this one could be entertaining. And frankly, for me, it's a good one to cover because I think there's a bigger audience. I mean, I the delete laws fans or anti-fans, we'll say, is a fairly limited group. It's it's a loyal, vocal, good group, but this one could be bigger. So hopefully, fingers crossed. But with that said, let's jump into the motion to dismiss. And it is 35 pages in response to delete law's 42-page complaint. Hopefully, we can get through this one much faster because, frankly, I'm not going to have to stop and correct Craig Anderson every 2 seconds. And I haven't fully read this. I've seen bits. I've seen Merb summarize it, I think. It appears to be more comprehensive. He does not like Jose DeCastro. So let's jump into it. And this is in the United States District Court for the District of Nevada. And it's Jose DeCastro, plaintiff, versus Las Vegas Metropolitan Police Department, State of Nevada, Brandon Bork, Jason Torrey, C. Dingle, B. Sorensen, Jesse Sandoval, Officer Doolittle, and Does 1 to 50, inclusive. So, first thing I notice looking at the caption here is Officer Sitco or Sitgo or Cisco or whatever the hell spelling delete laws chooses to use at any given time is not in this caption. But we'll also notice, looking at the docket, he hasn't been served. So as of this moment, he isn't Craig Anderson's attorney or client. He's not a party yet. I mean, he's not an appropriate party anyways, but he's not involved until he's served at the very least. Assuming he is an officer, what'll happen is Craig Anderson will probably then be appointed as his defense attorney because, why not? And he'll just basically do a motion saying, yeah, that motion to dismiss include Officer Cisco, Sitco, whatever in it. But it also does have State of Nevada, who is not represented by Craig Anderson, but the State of Nevada also has sovereign immunity, so fun stuff. But this is defendant's motion to dismiss plaintiff's Second Amended Complaint, or in the alternative, motion for summary judgment. Now, I think this is a good time to discuss this, actually. So let's look up the rules of civil procedure. So in his motion to reconsider delete laws, trying to get the judge to recuse himself, one of the things he's complaining about is he says, but judge, you used the standard for a summary judgment and not the standard for a motion to dismiss. And so you shouldn't have dismissed it. Well, the judge did use some language from summary judgment, but he did use the standard of motion to dismiss. But either way, so summary judgment is Rule 56. So let's look at 56B. Time to file a motion. Unless a different time is set by local rule or the court orders otherwise, a party may file a motion for summary judgment at any time until 30 days after the close of discovery. So you can actually, right out the gate, very first thing, file a motion for summary judgment. You can do it before you file a motion to dismiss, although that probably precludes you from filing a motion to dismiss. But you can do it before an answer. You can do it as part of your motion to dismiss. You can do it as part of your answer. So this is, I think, actually kind of smart by Craig Anderson, because remember, we've discussed this before, and okay, I was right. So Rule 8, general rules of pleading. So Delete Laws has a hard time with this one, as we saw with itchy back. But as we saw with his 42-page complaint, but the 8A, claim for relief. A pleading that states a claim for relief must contain 1. A short and plain statement of the grounds for the court's jurisdiction. A short and plain statement of the claim showing the pleader is entitled to relief, and a demand for the relief sought. 42 pages was not a short and plain statement. But that's not what we're after in Rule 8 today. We are after 8D2, alternative statements of a claim or defense. A party may set out 2 or more statements of a claim or defense alternatively or hypothetically, either in a single count or defense or in separate ones. If a party makes alternative statements, the pleading is sufficient if any one of them is sufficient. And on its face, that means, you know, I can say, I wasn't there. I wasn't there. I didn't do it. But even if I did do it, I was privileged to do it because of this. So that would be an alternative claim. But you can, procedurally, it's fine as well. I can't remember if there's a different rule as far as this, but either way, we don't need to do that too in depth. But so this is saying, please grant our motion to dismiss, or in the alternative, look at all the facts, including our facts, look at the undisputed facts, compare them, and say, well, yeah, there's no claim here. So I think what's probably going to happen is, well, number one, this is a way to get the body cam footage in, because for the summary judgment motion, hey, he can consider all of the pleadings, all of the facts that have been submitted. It's not limited like the complaint to the 4 corners of the complaint. It's not limited like the motion to dismiss to the 4 corners of the complaint. So what I think might happen, I'm going out on a limb here, but looking forward, the judge might grant the motion to dismiss in part and grant the summary judgment in part. So for the easy ones, like let's say the ones that have already been dismissed with prejudice that he has repled, the court doesn't have jurisdiction to hear those. Those have been dismissed with prejudice. So that is a very easy one to get rid of on the motion to dismiss. But the Monell claims that were, or the supervisor liability, whatever the claim that was not dismissed because Craig Anderson didn't do a super good job of disputing it in the first motion to dismiss, it should be dismissed, assuming he does a good enough job in this motion to dismiss. So most of them should be dismissed. But for like the battery claim, he other than incorporating the body camera into his complaint, it might still survive a motion to dismiss. But that one, they can grant partial summary judgment in favor of the defendant. What does that mean? It's dismissed with prejudice. They win. So this gives them two different mechanisms using two different legal standards for them to win, for the case to be dismissed, for everything to be dismissed. And it's a bad sign when I say I hope to do this one faster than yesterday, and I just spent 6 minutes discussing the title for the document, but I still think it was an important discussion because I think I really have a feeling that's what's going to happen. So stay tuned to future Joe, and I'll crow if that is the case. So, defendants, Las Vegas Metropolitan Police Department, LVMPD, Officer Torrey, Officer Bork, Officer Dingle, Officer Sorensen, Officer Sandoval, and Officer Doolittle, collectively defendants. Footnote 1. In the Second Amended Complaint, DeCastro named LVMPD Officer Sitko, or Cisco, as a defendant in this action. However, Sitko has not been served and is thus not a proper party to this action at this time. That's what I said earlier. Good job, Craig. By and through their attorneys of record, Markey Auerbach, hereby file their motion to dismiss plaintiff's Second Amended Complaint, or, in the alternative, motion for summary judgment. This motion is made and based upon the pleadings and papers on file herein, the memorandum of points and authorities attached hereto, and any oral argument allowed by counsel at the time of hearing. So, pleadings and papers on file herein. Now, I think by pleadings and papers, he's including the exhibits, although those aren't exactly papers, they're video. Memorandum of Points and Authorities. Introduction. At its core, this is a Section 1983 wrongful arrest and excessive force lawsuit. On March 15, 2023, defendant Brandon Bork arrested plaintiff Jose DeCastro for obstructing a lawful traffic stop when he approached the detainee of the traffic stop and subsequently refused to comply with Officer Bork's commands to move away from the detainee. After plaintiff filed his first amended complaint, the defendants moved to dismiss all DeCastro's claims except his excessive force claim. On October 23, 2023, this court issued its order granting in part defendant's motion to dismiss and granting plaintiff leave to amend certain claims. Plaintiff amended and filed his second amended complaint on November 11, 2023. The defendants now move to dismiss all DeCastro's claims pursuant to Federal Rule of Civil Procedure 12b6, or, in the alternative, summary judgment pursuant to Federal Rule of Civil Procedure 56. So we looked at 56 a minute ago, specifically 56b, time to file. DeCastro's Second Amended Complaint refers repeatedly to video recordings regarding the subject incident as support for his claims. Because DeCastro has incorporated these video references, the defendants are attaching copies of the defendant officer's body-worn camera videos from the subject event and DeCastro's own recording. The videos establish that the officers acted constitutionally and did not violate any of DeCastro's federal law or state law rights. So, like I said, he incorporated them by reference, the videos, into his complaint. So the defense is arguing, hey, these videos are within the four corners of the complaint. So the court needs to consider them. It's in the complaint, and it's pled as factual by delete laws. It's his fact, and the defense isn't going to dispute those facts. So for summary judgment, it's undisputed fact, the video. And it's in the, for the motion to dismiss, it's in the complaint, so it can be considered. It's to be taken as true in the video, or the video is supposed to be taken as true in the motion to dismiss because it's part of the complaint. Assuming the judge agrees with this analysis, which he should. Statement of facts and procedural history. Subject incident. In support of the instant motion, defendants submit body-worn camera video evidence from the perspective of the subject officers. Exhibit A, Bork body-worn camera. Exhibit B, Sandoval body-worn camera. Exhibit C, Dingle body-worn camera. Exhibit D, Sorensen body-worn camera. Exhibit E, Doolittle body-worn camera. And Exhibit F, Torrey body-worn camera. And they did. So the motion to dismiss was filed December 11th. The notice of manual filing by defendant was December 12th. So basically what this is they submitted a flash drive to the court clerk and said, yeah, this is the exhibit. These are the exhibits, and they filed this on the docket to indicate that. And I do notice that Craig Anderson did make a mistake in stating the procedure, because he said delete laws filed the Second Amended Complaint on November 21st, which is not quite true. He filed the motion to extend time on November 21st. So on the 21st, he said, but Judge, I'm too busy. I need more time because I'm so swamped. I mean, so that's what he filed on the 21st. The Second Amended Complaint was filed on the 27th. So this might not have actually been a galaxy brain move by Craig Anderson, because he might have actually thought he might have been doing the math based on November 21st, and So that he might have actually thought December 11th is when it was due, as opposed to the 18th. But either way, it doesn't really matter. In addition, the defendants submit the declarations of the defendant officers in support of the instant motion, authenticating the body-worn camera footage. Exhibit G, officer declarations. Additionally, DeCastro has custody and control of a YouTube channel, and he references his videos and recording of the subject incident multiple times in the Second Amended Complaint. DeCastro's YouTube video detailing the subject incident, which is comprised of his own video footage, clips of body-worn camera footage, and DeCastro's overlaid text commentary, is attached here too as Exhibit H. On March 15th, 2023, at approximately 4:30 p.m., Officer Bork conducted a traffic stop of a silver Hyundai Elantra. DeCastro approached the traffic stop while recording with his phone and began talking to the traffic detainee. Officer Bork was sitting in his LVMPD vehicle. As DeCastro approached the driver's side window of the detainee, Officer Bork exited his vehicle and told DeCastro, "Don't engage with my driver, back up." DeCastro did not follow Officer Bork's command, and Officer Bork reiterated, "Hey, back up, you're not involved." And you'll notice, like, "Don't engage with my driver, back up." The citation is to Exhibit A, Officer Bork's body-worn camera video, as opposed to the complaint. DeCastro was only a few feet away from the driver's side window of the traffic detainee. DeCastro backed up 1 or 2 feet, remaining in close proximity to the silver Hyundai Elantra and the driver's side window. Officer Bork clarified to DeCastro, "You can film, but you need to stay away from my driver. Back up." DeCastro did not move. Officer Bork then told DeCastro, "Back up, or I'm going to detain you." DeCastro replied, "You're going to detain me? How?" To which Officer Bork replied, "For obstructing. Get away from my car stop." DeCastro asserted that he would continue to stand right there, claimed that he was 10 feet away, and that he is a constitutional law scholar, and told Officer Bork that his name would be on the lawsuit, implying that any resistance to DeCastro's interference with the traffic stop would be met with legal action. Maybe he should be a TikTok psychic, am I right? Officer Bork attempted in vain to appeal to DeCastro's better nature by noting that the traffic detainee deserved privacy, to which DeCastro reminded, "Mind your own fucking business. Mind your own business. I'm a member of the press. Get in your car and do your job, little doggy." During the entirety of the initial interaction, DeCastro remained near the vehicle of the detained driver and refused to move. In light of DeCastro's obstructive conduct and refusal to comply with officer commands, Officer Bork told DeCastro, "You are being detained right now," and told the detained driver of the silver Hyundai Elantra that she was free to go. As Officer Bork approached DeCastro, he began to walk backwards, exclaiming that he was a journalist. "I'm a journalist. You can't arrest me." Ah! Sorry. Don't want to spill my water on the computer. DeCastro refused to comply and moved away from Officer Bork. Officer Bork called for additional units and reiterated that DeCastro was detained. DeCastro demanded a supervisor. I just love it when they demand a supervisor, and then when more units show up, they say, "You're trying to intimidate me by the number of officers here." Once again, it's gaslighting. It's abuser's handbook. Officer Bork then ordered DeCastro to walk over to Officer Bork's patrol car, to which DeCastro verbally agreed. Officer Bork reiterated that DeCastro was being detained for obstruction and ordered DeCastro to place his phone on the hood of the patrol vehicle. DeCastro refused, asserting that he is a constitutional law scholar and that Officer Bork could not take his phone. As Officer Bork approached DeCastro, DeCastro extended his arm and attempted to push Officer Bork away from him. Officer Bork proceeded to grab DeCastro and escort him to the space in front of his patrol vehicle. Yet another camera on him, the dash camera. At that time, Officer Dingle arrived on scene, and he and Officer Bork placed DeCastro in handcuffs despite DeCastro's continued resistance. DeCastro made Officer Bork aware of a prior shoulder injury, and Officer Bork placed DeCastro in 2 pairs of handcuffs to adhere to his medical needs. And as I've said previously, they were wide enough that DeCastro was able to have his wrists in front of the central plane of his body, on the front plane of his body. That's how much room he had to move with the handcuffs. His hands weren't behind his back, they were at his side. Not comfortable, but not torture either. DeCastro claims he was patted down and struck in the groin with a closed fist. Officer Dingle's body-worn camera captured the alleged groin strike. The video establishes that Officer Bork's pat-down of DeCastro was routine, harmless, and that Officer Bork did not strike DeCastro's genitals. Like he could find them anyway. DeCastro never flinched or complained of pain. Shortly thereafter, Officer Sandoval and Officer Sorensen arrived on the scene. After observing DeCastro's recalcitrance, that's a good word, recalcitrance, Officer Sandoval explained to DeCastro that the officers had a way to do things, and that DeCastro's continued refusal to obey officer commands would result in his arrest for obstruction. DeCastro retorted, "I have a way to do things too. I sue cops all over the country. That's what I do." You just don't succeed at it. The defendant officers ordered that DeCastro continue to face the patrol vehicle. DeCastro proceeded to resist and failed to comply with that order for the next several minutes, while arguing with and taunting the defendant officers. Due to DeCastro's continued willful disobedience of the officer's order for him to face the patrol vehicle, Officer Sandoval proceeded to stand behind DeCastro and hold his left arm to ensure DeCastro's compliance with the officer's order. DeCastro repeatedly asserts in the Second Amended Complaint that Officer Sandoval was squeezing his arm and causing him pain. Poor little schnookums. He got an owie. However, the footage clearly demonstrates that Officer Sandoval was holding DeCastro's arm in a reasonable manner and not applying any significant force to DeCastro's arm. DeCastro repeatedly pulled away from Officer Sandoval and, as a result, was placed in the back of Officer Bork's patrol vehicle. Shortly thereafter, defendant Erland Jason Torrey, Sergeant Torrey, arrived at the scene. Sergeant Torrey had a conversation with DeCastro in which he represented that he had reviewed the body-worn camera and believed DeCastro was clearly obstructing on account of interfering with the traffic stop and refusing to step back when commanded to do so, and that when Officer Bork told DeCastro he was being detained, DeCastro proceeded to resist. After Officer Bork explained what DeCastro did wrong, DeCastro requested that they work it out and not arrest him in order to avoid his bringing a lawsuit and causing LVMPD to incur substantial attorney fees in defending the lawsuit. I'd be using that in my request for attorney fees from delete laws. During the conversation, Sergeant Torrey made clear to DeCastro that there was no issue with him filming the traffic stop, but that being up close to the car stop, ignoring officer commands, and resisting detention/arrest were the reasons he was being arrested. As noted in Officer Bork's report and affirmed by Sergeant Torrey and the body-worn camera, the reasons why DeCastro was arrested was for engaging with a detained driver, refusing to give an officer reasonable space to work, and refusing to obey lawful commands after being advised he was being detained. What's missing from that list? What's not on that list? He was not arrested for filming. Sergeant Torrey made clear to DeCastro that there was no issue with him filming the traffic stop. That would indicate he was not arrested for filming, despite the many claims in his complaint. I would call him a lying sack of shit. But I think that would be rather unkind to a lying sack of shit. But that's just my opinion. Officer Bork's report further stated DeCastro had admitted to getting in trouble numerous times in the past for the same reasons, and his habitual behavior of obstructing police officers and claiming it was justified because of his right to film the police would continue in the area if he was not cited. Now, that looks awfully different from what Delete Law says. Delete Law says, they defamed me. They said I have a criminal record. They said I'm a criminal. They said he'd been in trouble in the past. Well, they said he had told them that he had done this in the past, that it had been problematic in the past. That's not defamation. That's true. And it doesn't match up with what he's trying to claim. But once again, see my previous comment about lying sacks of shit. Procedural history. Plaintiff's First Amended Complaint and this court's order. This one should be fun, talking about things that have been dismissed with prejudice. On April 17th, 2023, DeCastro filed the instant lawsuit. On May 7th, 2023, DeCastro amended his complaint. The First Amended Complaint alleged 1. Section 1983, excessive force. 2. Section 1983, equal protection violation. 3. Section 1983, First Amendment violations. 4. Section 1983, Monell liability against LVMPD. 5. 42 U.S.C. Section 1981 claim. And 6. State law claims for assault, battery, false arrest, invasion of privacy, and negligence. Defendants filed a motion for partial dismissal. The defendants moved to dismiss most of DeCastro's First Amended Complaint. On October 23rd, 2023, this court issued its order granting, in part, defendants' motion to dismiss. Specifically, this court dismissed with prejudice. Underlined right there, underlined, with prejudice, DeCastro's claims for unreasonable search and seizure, false imprisonment, invasion of privacy, and negligence based on search and seizure. This court also dismissed without prejudice DeCastro's equal protection claim, First Amendment retaliation claim, Monell claim, Section 1981 claim, and negligence-based claim for biased policing without prejudice. DeCastro's excessive force and supervisor liability claims survived. The tip of my nose is itchy. This court gave DeCastro leave to amend the claims dismissed without prejudice. DeCastro's Second Amended Complaint. DeCastro has now amended his claims and filed his Second Amended Complaint. It contains the following causes of action. First claim for relief, 42 U.S.C. Section 1983, Fourth Amendment false arrest against the officers. Second claim for relief, 42 U.S.C. Section 1983, Fourth Amendment illegal search and seizure claims. Third claim for relief, 42 U.S.C. Section 1983, Fourth Amendment excessive force against Bork and Sandoval. Fourth claim for relief, Nevada state law defamation claims against officers Bork, Torrey, Dingle, Sorensen, Sandoval, and Doolittle. Fifth claim for relief, 42 U.S.C. Section 1983, First Amendment chilling claim against all defendants. And that chilling is in quotation marks because First Amendment chilling isn't a recognized cause of action. He's making shit up. Sixth claim for relief, 42 U.S.C. Section 1983 First Amendment retaliation claim against all defendants. Seventh claim for relief, 42 U.S.C. Section 1983 Monell liability claim against LVMPD, the state of Nevada, and Sergeant Torrey. Eighth claim for relief, 42 U.S.C. Section 1983 selective enforcement and unequal police action claim against all defendants. Ninth claim for relief, Nevada state law battery claims against Officer Sandoval. 10th claim for relief, Nevada state law invasion of privacy claim against officers Bork, Sandoval, Torrey, Dingle, Sorensen, and Doolittle. 11th claim for relief. Do you think they got Officer Doolittle on scene to attempt to speak to Charlie, or thinking he could have a better job communicating with delete laws? Just a thought. 11th claim for relief, Nevada state law negligence claim against all individual defendants. 12th claim for relief, 42 U.S.C. Section 1983 failure to intervene claim against all individual defendants. 13th claim for relief, Nevada state law civil conspiracy claim against all individual defendants. Once again, RICO is the legal equivalent of lupus. 14th claim for relief, Nevada state law abuse of process claim against officers Bork, Sandoval, Torrey, Dingle, Sorensen, and Doolittle. And the 15th claim for relief, 42 U.S.C. Section 1983 Monell failure to train claim against Officer Torrey, LVMPD, and the state of Nevada. The defendants now move to dismiss all claims. Legal standard, motion to dismiss / motion for summary judgment. A motion to dismiss under Federal Rule of Civil Procedure 12b-6 tests the legal sufficiency of the claims asserted in the complaint. The issue on a motion to dismiss for failure to state a claim is not whether the claimant will ultimately prevail, but whether the claimant is entitled to offer evidence to support the claims asserted. And that's Gilligan versus Jamco Development Corp., 9th Circuit, 1997. When evaluating a 12b-6 motion, the district court must accept all material allegations in the complaint as true and construe them in the light most favorable to the non-moving party. That's Moyo versus Gomez, 9th Circuit, 1994. If a plaintiff will not be entitled to relief under any set of facts that could be proven under the allegations of the complaint, the court may, sua sponte, dismiss the cause of action or portions thereof. That's Halt versus Wind Innovation or Investment Company, I assume, Ninth Circuit, 1982. And sua sponte means on its own. Here, defendants request the court utilize the officer's body-worn camera and DeCastro's own YouTube video to determine whether DeCastro has stated claims upon which relief can be granted pursuant to Rule 12b-6, and to determine whether the defendant officers are protected by qualified immunity. A court may look to matters of public record or to documents on which the complaint necessarily relies if their authenticity is not contested. That's Sams versus Yahoo Inc., Ninth Circuit, 2013. Courts rely on video evidence in ruling on 12b-6 motions if the footage was incorporated into the complaint by reference and were documents that partially formed the basis of plaintiff's complaint. And that's the case here. He relied on the body-worn camera. He didn't specifically say, I'm incorporating these by reference, but he referenced them multiple times. That would be incorporating them by reference. And he also did that with the police reports. He referenced them multiple times and what they said, why he disagreed with them, how they were defamation because they were released to the public as public records. So they partially formed the basis of delete law's complaint. And CEG, Covert versus City of San Diego, Southern District of California, 2017. Muhammad versus City of Phoenix, District of Arizona, 2019, which said courts can consider public records such as body-worn camera if it is a matter of public record and not disputed. And see also Lihosit versus Flam, District of Arizona, 2016. Courts may take judicial notice of matters that can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned. That's Federal Rule of Evidence 201B. And the body-worn camera is a public record. And delete law's own video. Like, if he reasonably questions the accuracy of his own video of the event, well, that's a great big ding against his credibility, because if he says, well, you can't rely on this, the reliability is questioned. It's not accurate. Well, why isn't it accurate? Did you manipulate it somehow? Did you edit it? Did you cut things out? So either he can't question it, or if he questions it, it's like, well, then what weight should we give it anyway? And you saying this happened, it's on my video, why should we believe it if you're questioning its accuracy? So this is kind of important, because if he says, well, this can't be admitted as evidence under Rule 201B, well, then that really impacts your credibility. So he's got to let it in. He can't dispute it, and that hurts him big time. The incorporation by reference doctrine permits a court to take into account documents whose contents are alleged in a complaint and whose authenticity no party questions, but which are not physically attached to the plaintiff's pleading. That's Knievel versus ESPN, Ninth Circuit, 2005. I assume 2005, that's probably Robbie Knievel, not Evil Knievel. With respect to police excessive force cases, the Supreme Court has held that a court should use video evidence when available in deciding an officer's reasonableness. That's Scott versus Harris, Supreme Court 2007. Plumhoff versus Rickard, Supreme Court 2014. Mason versus LVMPD, Ninth Circuit 2019. DeCastro's Second Amended Complaint repeatedly references his own video footage and a YouTube video that DeCastro created and published. The Second Amended Complaint perpetually references the video of this incident. DeCastro's references to videos, footage, and cameras can also be understood to be referring to the body-worn camera footage, which he refers to directly in the Second Amended Complaint. Defendants have attached the officer's body-worn camera videos along with declarations from the officers attesting to their authenticity. In addition, the allegations set forth in the Second Amended Complaint track the video footage, and the footage is the basis for the Second Amended Complaint's factual allegations. If this court determines that the body-worn camera and DeCastro's own footage is outside the Second Amended Complaint, the court may then convert the motion into a motion for summary judgment under Rule 56, where both parties have the opportunity to present all the material that is pertinent to the motion. And like I said, I think what the court might do is the things that it doesn't need to rely on the body-worn camera for, it will dismiss under the rule, under the motion to dismiss. And for those things it needs to incorporate the body-worn camera for, it will grant summary judgment on those issues, thereby dismissing the rest of the claims. Although that is if the court does not incorporate the body-worn camera footage into the complaint. So the court should incorporate it, and that should permit it to dismiss everything on the motion to dismiss. But here's why I think it might not do that. The path of least resistance might be to dismiss in part and summary judgment in part, because that cuts off avenues for appeal. It's a little more clunky, but it's a little more sound. It's easier to justify, which isn't like I said, I 100% think that the court should incorporate the video, but it might be easier not to and just do a mixed ruling. So that's why I think that's going to happen, but I could be wrong. I don't see any claim surviving this motion, whether it's all on one side, all on the other side, or a mix. I think everything will be dismissed under some mechanism, whether it's Rule 12 or Rule 56. So let's start that paragraph again, because if this court determines that body-worn camera and DeCastro's own footage is outside the Second Amended Complaint, the court may then convert the motion into a motion for summary judgment under Rule 56, where both parties have the opportunity to present all the material that is pertinent to the motion. Federal Rule of Civil Procedure 12D. Let's take a look at 12D. Because remember, 12B6 is the motion to dismiss for failure to state a claim upon which relief can be granted. But D, result of presenting matters outside of the pleadings. If on a motion under Rule 12B6 or 12C, matters outside the pleadings are presented to and not excluded by the court, the motion must be treated as one for summary judgment under Rule 56. All parties must be given a reasonable opportunity to present all the material that is pertinent to the motion. So that's 12D. But once again, that's if the matters are outside the pleadings and are presented. But once again, he presumably incorporated the videos by reference. That should be the ruling. But if it isn't, hey, treat it as Rule 56 motion for summary judgment. Although, once again, that this is saying even if Craig Anderson hadn't styled it as motion to dismiss or in the alternative motion for summary judgment, this says, hey, the court, if it's not going to consider these pleadings presented to the court, if we're going to exclude them, we need to treat it as Rule 56. So this is more of a stopgap than, you know, Craig Anderson, he filed it in the alternative anyway, so that's fine. So under Rule 56 of the Rules of Federal Procedure, that's awkward. The Rules of Federal Procedure, that why not just put Federal Rules of Civil Procedure? That's just awkward. But a party may move for summary judgment identifying each claim or defense or the part of each claim or defense on which summary judgment is sought, and the court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. That's Rule 56A. And remember, 56B says, hey, you can, unless there's a rule that says otherwise, you can bring the summary judgment motion at any time before 30 days after the close of discovery. It is not uncommon for courts to utilize video at the motion to dismiss stage and convert the motion into a summary judgment motion. C.E.G. Helmbrecht versus Henderson Police Department, District of Nevada, 2022. Relevant 42 U.S.C. Section 1983 legal standards. 42 U.S.C. Section 1983 is not itself a source of substantive rights, but merely the procedural vehicle by which to vindicate federal rights elsewhere conferred. See Albright versus Oliver, Supreme Court, 1994. To make out a prima facie case under Section 1983, a plaintiff must show that a defendant, 1, acted under color of law, and 2, deprived the plaintiff of a constitutional right. See Borunda versus Richmond, 9th Circuit, 1989. The defendant officers do not dispute that they acted under color of law. Therefore, the task of this court is to determine whether the defendant officers violated the Constitution. See Albright. In addition, the defendant officers have raised the affirmative defense of qualified immunity. A defendant in a Section 1983 action is entitled to qualified immunity from damages for civil liability if his conduct did not violate clearly established statutory or constitutional rights of which a reasonable person would have known. That's Harlow versus Fitzgerald, Supreme Court, 1982. The Supreme Court has often stressed the importance of deciding qualified immunity at the earliest possible stage in litigation in order to preserve the doctrine's status as a true immunity from suit rather than a mere defense to liability. That's Hunter versus Bryant, Supreme Court, 1991. And Delete Laws disagrees with the Supreme Court on that. He thinks, hey, the motion to dismiss is way too early to determine qualified immunity. But if it's an immunity from suit, why go through discovery if it can already be determined that qualified immunity applies? But Delete Laws disagrees. In determining whether an officer is entitled to qualified immunity, a court considers 1. Whether there has been a violation of constitutional right, and 2. Whether that right was clearly established at the time of the officer's alleged misconduct. That's Lull versus California, 9th Circuit, 2014. Consequently, at summary judgment, a court can only deny an officer qualified immunity in a Section 1983 action if 1. The facts alleged, taken in the light most favorable to the party asserting injury, show that the officer's conduct violated a constitutional right, and 2. The right at issue was clearly established at the time of the incident such that a reasonable officer would have understood his conduct to be unlawful in that situation. That's Torres versus City of Madera, 9th Circuit, 2011. So Delete Laws would have to show that he had a constitutional right to interfere with a traffic stop, to obstruct, to resist arrest, because once again, he does have a constitutional right to film, but he was not arrested for filming. They told him, you can film, that's fine. You have to back up. And you can't talk to our detained driver because she's our detained driver. That's interfering. Legal argument. This court has already dismissed DeCastro's 1st, 2nd, 10th, and 11th causes of action with prejudice. DeCastro's Second Amended Complaint reasserts his claims for unreasonable search and seizure based on the arrest and search, 1st and 2nd cause of action, invasion of privacy, 10th cause of action, and negligence based on the arrest and search, 11th cause of action. This court has already dismissed these claims with prejudice. Accordingly, defendants request that this court strike those claims from the Second Amended Complaint or reaffirm their dismissal with prejudice. I'd also be asking for attorney's fees and sanctions because this is BS. DeCastro's 42 U.S.C. Section 1983 claims fail as a matter of law. DeCastro's 4th Amendment excessive force claim fails, the 3rd cause of action. 4th Amendment excessive force legal standards. In evaluating a 4th Amendment excessive force claim, a court asks whether the officer's actions are objectively reasonable in light of the facts and circumstances confronting them. And that's Graham versus Connor, Supreme Court, 1989. The calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. So that reminds me of a comment I got on yesterday's video from Indiana accountability or auditor or whatever. I don't care what his name is. I've never watched him. I never will. His comment was dumb. But he took issue with the fact that I agreed that the Arizona 8-foot law was unconstitutional, and that when auditors say, this court ruled that 15 feet is reasonable, this court ruled that 20 feet is reasonable, this court ruled that 3 inches is reasonable, and it's like, but that's under those facts and circumstances. And I said, an officer needs discretion. A hard and fast rule on this distance is reasonable by law doesn't work. And this is why. Officers are humans. They need to make split-second decisions. They need to determine, based on the circumstances on the scene, what distance is safe, what distance is reasonable. And tying their hands on that, you're going to have a bad time. So, as I've said before, I'm naturally fairly skeptical of the police. There are bad police out there. This instance was not one of them. And this, I like this quote. I like this citation. Let's read it again. This is for you, Indiana auditor, accountability, numbskull, whatever. The calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. And once again, that's the Supreme Court in Graham versus Connor. Now, that's about the amount of force, not the distance, but the same analysis applies. Reasonableness must therefore be judged from the perspective of a reasonable officer on the scene, rather than with the 2020 vision of hindsight. And Indiana numbskull, whatever you are, you're not going to get that in the law library. To determine the reasonableness of the officer's actions, a court must assess the severity of the intrusion on the individual's Fourth Amendment rights by evaluating the type and amount of force inflicted. That's Glenn versus Washington City, Ninth Circuit 2011, which quoted Espinosa versus City and County of San Francisco, Ninth Circuit 2010. Even in cases where some force is justified, the amount actually used may be excessive. That's Santos versus Gates, Ninth Circuit 2002. The defendant officers used reasonable force to detain DeCastro. The first step in the qualified immunity analysis is to determine whether the officers violated a constitutional right, i.e., whether the officers' use of force was objectively reasonable under the totality of the circumstances. That's from Graham. DeCastro is alleging the officers used excessive force while detaining him, and that Officer Bork intentionally punched his genitals during the pat-down, and Officer Sandoval excessively pinched his arm tightly. You pull away, they're going to grab your arm tighter. First, Officer Bork used reasonable force in detaining the admittedly resisting and obstructive DeCastro. The video shows DeCastro attempting to avoid Officer Bork and even attempting to push him away, i.e., active resistance. In response, the only force used by Officer Bork was basic empty hand tactics designed to control DeCastro and counter his resistance. This force was clearly reasonable. See Graham, once again, which says, our Fourth Amendment jurisprudence has long recognized that the right to make an arrest or investigatory stop necessarily carries with it the right to use some degree of physical coercion or threat thereof to effect it. Or should I say, coercion. And Schaefer versus County of Santa Barbara, 9th Circuit 2017, which said, Schaefer's primary argument on appeal is that Deputy Padilla had no basis for using any force whatsoever. We disagree. Deputy Padilla had probable cause to use some degree of force. Thus, the video clearly establishes that Officer Bork's empty hand techniques to control the resisting DeCastro were reasonable. Similarly, DeCastro's claim that Officer Sandoval excessively squeezed his arm is refuted by the video evidence. The videos clearly show that Officer Sandoval maintained a grip on DeCastro's arm due to the fact he continued to move, twist, and slightly resist after handcuffing. As explained to DeCastro by Officer Sandoval, because DeCastro was handcuffed and lacked the use of his hands, Officer Sandoval needed to maintain control of DeCastro so that he did not fall and injure himself. This is objectively reasonable. Finally, DeCastro's allegation that Officer Bork intentionally struck him in the groin is refuted by the video evidence. Admittedly, it would be excessive force for an officer to gratuitously strike a restrained suspect in the groin. The video confirms this did not happen. It shows that Officer Bork performed a routine pat-down for weapons and that he never struck DeCastro. Indeed, the video shows that DeCastro never even flinched or reacted to the alleged strike. Not every push or shove violates the Fourth Amendment. That's, once again, Graham, Supreme Court. Thus, DeCastro's allegation of Officer Bork gratuitously struck his genitals is blatantly contradicted by the video evidence. See Hughes versus Rodriguez, 9th Circuit 2022, wherein an inmate's allegations could be ignored as they were blatantly contradicted by the video evidence. Finally, at a minimum, there is no clearly established law prohibiting an officer, 1, from using empty-hand techniques to pull a suspect resisting arrest, 2, maintaining a hold of a suspect's arm when the suspect is handcuffed and continuing to twist and turn and disobey clear orders, or 3, perform a routine pat-down that includes contact at or near the groin area. Thus, qualified immunity is appropriate under the clearly established prong, as well as the merits. DeCastro's First Amendment retaliation and selective enforcement claims fail, 5th, 6th, and 8th causes of action. DeCastro has separately asserted claims for chilling of First Amendment rights, 5th cause of action, First Amendment retaliation, 6th cause of action, and selective enforcement, 8th cause of action. A claim for chilling of First Amendment rights is not a cognizable cause of action. In other words, he's making shit up. Rather, the analysis of whether a defendant's actions would chill a person of ordinary firmness from continuing to engage in a constitutionally protected activity is an element of a First Amendment retaliation claim. C.E.G. Cap versus County of San Diego, 9th Circuit, 2019. Accordingly, defendants will analyze DeCastro's 5th and 6th cause of action as a singular First Amendment retaliation cause of action. In addition, DeCastro's selective enforcement claim is closely related to this claim and, therefore, will also be analyzed in this section. First Amendment retaliation and First and 14th Amendment selective enforcement legal standards. There are three elements to a First Amendment retaliation claim. A plaintiff must show that, 1, he was engaged in a constitutionally protected activity. Interfering with a traffic stop is not a constitutionally protected activity. 2, the defendant's actions would chill a person of ordinary firmness from continuing to engage in the protected activity. And 3, the protected activity was a substantial or motivating factor in the defendant's conduct. That's O'Brien versus Welty, 9th Circuit 2016, which itself cited Pinard versus Klatskanee School District, 9th Circuit 2006. I'm assuming Klatskanee must be in Oregon. That's definitely a Pacific Northwest type name. To ultimately prevail on such a claim, a plaintiff must establish a causal connection between the government defendant's retaliatory animus and the plaintiff's subsequent injury. That's our old friend Neves versus Bartlett, Supreme Court, 2019, quoting Hartman versus Moore, Supreme Court, 2006. Specifically, a plaintiff must show that the defendant's retaliatory animus was a but-for cause, meaning that the adverse action against the plaintiff would not have been taken absent the retaliatory motive. And that's Neves and quoting Hartman. And that if I weren't a 2-year-old, I wouldn't do this, but I am, so what's a but for? Pooping. However, a plaintiff may not recover merely on the basis of a speculative chill due to generalized and legitimate law enforcement initiatives. That's Gibson versus United States, 9th Circuit, 1986, citing Laird versus Tatum, Supreme Court, rehearing denied, 1972. In Neves, the U.S. Supreme Court adopted the no probable cause rule in relation to retaliatory arrest claims. If the plaintiff cannot make a showing that the arrest was not supported by probable cause, a retaliatory arrest claim fails. The Neves Court, in enacting the no probable cause rule, noted that the no probable cause requirement should not apply when a plaintiff presents objective evidence that he was arrested when otherwise similarly situated individuals not engaged in the same sort of protected speech had not been. That's Neves, once again. To prevail on an equal protection selective enforcement claim, the plaintiff must show that enforcement had a discriminatory effect and the police were motivated by a discriminatory purpose. That's Lacey versus Maricopa County, 9th Circuit 2012, which was an en banc decision. En banc meaning it wasn't heard by 3 9th Circuit judges, it was heard by the entire 9th Circuit. Enforcement may be shown through a variety of actual or threatened arrests, searches and temporary seizures, citations, and other coercive conduct by the police. A discriminatory effect may be shown if similarly situated individuals were not prosecuted. The standard for proving discriminatory effect is a demanding one, and that's from Lacey. See also Freeman versus City of Santa Ana, 9th Circuit, 1995, which said, it is necessary to identify a similarly situated class against which the plaintiff's class can be compared. And this is where, in yesterday's discussion of the Second Amended Complaint, he kept trying to say, look, this person, when I was filming, this person wasn't arrested. And when I was filming, this person wasn't arrested. But when I was filming in this case, I was arrested. But you, the subject of the traffic stop not being arrested is irrelevant. You've just shown in the case where you were close enough and didn't back up, you were arrested. In the other cases, you don't show that the cops told you to back up and you didn't, and you weren't arrested. You see the difference? I realize he doesn't, but he's an imbecile. He is a moron. Someone told me in the comments I need to promote him from Captain Conclusory to General Conclusory, but I'm not going to do that because, well, number one, I don't think he deserves it. I'm saving higher ranks for other people, but also I like the alliteration. So his highest promotion potential anyways would be Colonel Conclusory. Although we can have some naval Commander Conclusory, still captain, but for lesser offenses, there's Corporal Conclusory. Those are the military ranks I can think of off the top of my head, starting with C. Finally, to show discriminatory purpose, the plaintiffs must show the police decided to enforce the law against them based on the exercise of their constitutional rights. A similar claim arises under the First Amendment, where discriminatory enforcement of a speech restriction amounts to viewpoint restriction. That's Minotti versus City of Seattle, 9th Circuit, 2005, and Foti versus City of Menlo Park, 9th Circuit, 1998. And I think Delete Laws is trying to assert this. You arrested me because I hate the police. And so you're discriminating against my viewpoint that you guys are scum. But once again, they arrested him because he wouldn't back up. It's that simple. They told him, keep filming. That's fine. The First Amendment retaliation claim fails because the officers had probable cause to arrest DeCastro. This court has already determined that the defendant officers had probable cause to arrest DeCastro for obstruction. The video footage submitted in support of the instant motion only further reinforces the court's prior determination of the existence of probable cause. So, despite Delete Laws trying to yoink out the facts in the Second Amended Complaint, remember we discussed it in the First Amended Complaint. He talked about the office. Well, number one, he changed it from the Jane Doe to I didn't know that she was detained. To me it looked like a voluntary encounter. But then he says, Officer Bork told me to back up. I did. And then he arrested me in the Second Amended Complaint. Whereas in the First Amended Complaint, it said, Officer Bork told me to back up. I backed up a little. He told me to back up more, and I refused. And so the judge found probable cause based on that. So he took out that entire second part. He didn't even mention in the Second Amended Complaint that Officer Bork told him to back up more. He thought he was being clever. The court can't find again that there was probable cause to arrest me, even though it already did, because this is a new complaint. So those causes of action that the court dismissed with prejudice, well, this is a new complaint, so that this erases that old complaint, and so the court can't, give judicial notice to its former ruling saying, yeah, there is probable cause. But then he included the video. He incorporated it by reference. So that just further reinforces that there was probable cause. Brilliant. Thus, pursuant to Neves, DeCastro's First Amendment retaliation claim fails as a matter of law unless DeCastro can present objective evidence that he was arrested when otherwise similarly situated individuals not engaged in the same sort of protected speech had not been. Here, DeCastro provides no factual allegations suggesting that other individuals who illegally interfered with traffic stops were not arrested. As such, this claim fails as a matter of law. DeCastro has not adequately alleged selective enforcement. DeCastro also claims that defendants selectively enforce laws against people with white lips, brown skin, people that expressed criticism towards law enforcement, those recording police interaction, and those publicizing information on police misconduct. However, DeCastro has not offered any facts beyond these conclusory statements. Captain Conclusory rides again. As discussed in this court's original order, DeCastro must plead plausible facts that support these claims. His failure to do so mandates these claims be dismissed. It remains undisputed that DeCastro interfered in a traffic stop, willfully and actively disobeyed lawful commands, resisted the efforts of the officers to effectuate his detention, and taunted and demeaned the officers. Although DeCastro was detained for misdemeanors, which usually result in a citation and not an arrest, the officers were correct to determine that DeCastro should be arrested because his behavior gave the officers reasonable cause to believe that the violation for which DeCastro was arrested would continue in the area if DeCastro was not arrested. In sum, DeCastro has not alleged the existence of an individual who engaged in substantially similar conduct and was not arrested for obstruction. As a result, DeCastro has failed to state a claim upon which relief can be granted for his claim of selective enforcement pursuant to the First and 14th Amendments to the U.S. Constitution. Next up, there is no clearly established law preventing officers from arresting an individual for obstruction under these facts. If this court concludes that DeCastro has pled sufficient facts demonstrating that a constitutional violation occurred, this court must then address the second prong of the qualified immunity analysis. Because you don't even have to do the second prong if the first prong fails, which it should. But just in case, let's discuss why the second prong also fails. And that second prong is whether the law regarding the constitutional violation was clearly established at the time. And that's law, which we saw above. I think that was Ninth Circuit. It is the plaintiff who bears the burden of showing that the rights allegedly violated were clearly established. And that's Schaefer. And he must provide a case that demonstrates the unconstitutionality of the action in light of the specific context of this case. See Mullinex, which is a Supreme Court case, which I don't remember that being cited already, so this should be a complete citation, not a quick cite. But either way, there is no clearly established law preventing officers from arresting an individual for obstruction under these facts. Specifically, DeCastro interfered in a traffic stop, willfully and actively disobeyed lawful commands to stand back from the traffic stop, resisted the efforts of the officers to effectuate his detention, all while repeatedly asserting that he was in the right and demonstrating no contrition towards his actions. Defendants are not aware of any case in which arresting an individual for obstructing under similar factual circumstances was found to be a First or 14th Amendment violation. Accordingly, there is no clearly established law, and the defendant officers are entitled to qualified immunity on DeCastro's First Amendment retaliation claims and First and 14th Amendment selective enforcement claim. Next up, DeCastro's failure to intervene claim fails. 12th cause of action. A failure to intervene, aka failure to intercede, claim is a subpart of the Fourth Amendment right to be free of excessive force. That's Cunningham versus Gates, Ninth Circuit 2003, which says police officers have a duty to intercede when their fellow officers violate the constitutional rights of a suspect or other citizen. Generally, a failure to intervene claim exists when bystander officers have an opportunity to intervene but fail to do so. That's Lawley versus County of Orange, Ninth Circuit, 2003, which says the constitutional right violated by the passive defendant is analytically the same as the right violated by the person who uses excessive force. That's U.S. versus Kuhn, Ninth Circuit, 1994. A more recent example, see Derek Chauvin and his goon squad who failed to intervene. Importantly, however, officers can be held liable for failing to intercede only if they had an opportunity to intercede. That's Cunningham versus Gates. The Ninth Circuit has only recognized a claim for failing to intervene in the excessive force context. So they could have only intervened if they had an opportunity to intervene, and that only applies to them squeezing Schnookham's elbow or hitting his nuts. So the arrest, there was no duty to intercede even if they were wrong, according to this. So police officers do not have a general duty to intervene in all alleged wrongdoings by a fellow officer. That's Briscoe versus Madrid, Eastern District of California, 2018, Dental versus City of Salem, District of Oregon, 2015. The duty to intercede is clearly limited to the context of excessive force claims under the Fourth Amendment. That's Dental, which found that the duty to intercede did not apply to the plaintiff's wrongful arrest claim. And Gillette versus Malheur County, District of Oregon, Milk versus City of Phoenix, District of Arizona, 2016, and Gillette was also 2016. But Milk says, found no duty to intervene outside of excessive force context. As established above, DeCastro has failed to state a claim upon which relief can be granted that the defendant officers violated his First, Fourth, or 14th Amendment rights. As a result, DeCastro necessarily fails to state a claim upon which relief can be granted based on the defendant officer's alleged failure to intervene. As stated above, this claim should only apply to DeCastro's excessive force claim, even if Officer Bork gratuitously struck DeCastro's genitals. The event happened in just a second, and none of the other officers had a legitimate opportunity to stop the alleged excessive force. And I don't know what that loud noise was, since it's 1:40 in the morning. I'm the only one that should be awake right now. So clearly my house is haunted. Although it could be the furnace, boiler, water heater, all that stuff is right on the other side of that wall under the front porch. To the extent the court believes that DeCastro has stated a claim for constitutional violation, or that a dispute of facts precludes a determination as to the existence of a constitutional violation, the defendant officers are protected by qualified immunity. Because the law was not clearly established, it was not clear to the defendant officers that they had a duty to intervene and stop the conduct of any of their fellow officers. Next up, DeCastro has failed to state a Monell claim upon which relief can be granted. DeCastro alleges two causes of action which he identifies as Monell claims. DeCastro alleges a claim for Monell supervisor liability based on the subject incident, seventh cause of action, as well as a Monell failure to train claim, 15th cause of action. Because both claims are brought against defendant LVMPD pursuant to Monell, defendants will analyze the claims in conjunction. Monell applicable law. In Monell, the court held that when a municipal policy of some nature is the cause of the unconstitutional actions taken by municipal employees, the municipality itself will be liable. And that's Monell versus Department of Social Services, Supreme Court, 1978. Liability only exists where the unconstitutional action implements or executes a policy, statement, ordinance, regulation, or decision officially adopted and promulgated by municipal officers, or where the constitutional deprivation is visited pursuant to governmental custom, even though such a custom has not received formal approval. The court defined custom as persistent and widespread discriminatory practices by state officials. That's Monell, which cites Adikas versus S.H. Dress and Co., Supreme Court, 1970. The doctrine of respondeat superior does not apply to 42 U.S.C. Section 1983 claims against municipalities. That's Pembauer versus City of Cincinnati, Supreme Court, 1968, which itself cites Monell. In other words, municipal liability is not clearly established, or not established merely by showing that a municipal employee committed a constitutional tort while within the scope of employment. For liability to attach to a municipality, a plaintiff must establish that the wrongful act complained of was somehow caused by the municipality. That's Monell. Such liability can be imposed only for injuries inflicted pursuant to a governmental policy or custom. In addition, there must be shown to be an affirmative link between the policy or constitutional violation alleged. That's City of Oklahoma City versus Tuttle, Supreme Court, 1985. The alleged policy or custom must be the moving force for the constitutional violation in order to establish liability under Section 1983. That's Polk County versus Dodson, Supreme Court, 1981, which cites Monell. Causation must be specific to the violation alleged, meaning that merely proving an unconstitutional policy, practice, or custom, however loathsome, will not establish liability unless the specific injury alleged relates to the specific unconstitutional policy proved. That's Board of County Commissioners of Bryan City, Oklahoma versus Brown, Supreme Court, 1997. Once each of these elements are met, a plaintiff must further prove that the unconstitutional policy that caused his injury was the result of something more than mere negligence on the part of the municipality, and was instead the result of deliberate indifference a state of mind that requires a heightened level of culpability, even more than mere indifference. In fact, the Monell standard for municipal liability has been interpreted as more restrictive than common law restrictions on private employers' liability for punitive damages. See David Jacks Achtenberg, Taking History Seriously, Municipal Liability under 42 U.S.C. Section 1983, and the debate over Respondeat Superior, Fordham Law Review article from 2005. So that's not binding authority. That's just persuasive. It's not case law, but it's, probably written by a law professor discussing the concept. Proof of a single incident is insufficient to establish a custom or policy. That's Tuttle. To properly plead a Monell claim against LVMPD, a plaintiff must 1. Identify the challenged policy or custom. 2. Explain how the policy or custom is deficient. 3. Explain how the policy or custom caused the plaintiff harm. And 4. Reflect how the policy or custom amounted to deliberate indifference, i.e., show how the deficiency involved was obvious and the constitutional injury was likely to occur. That's Harvey versus City of South Lake Tahoe, Eastern District of California, 2012. So let's go back to the Second Amended Complaint. Make it big. So, delete laws, count 7 is the Monell claim. At least we'll look at it. There's 2 Monell claims, but so these are the policies or customs or illegal laws that he's claiming. And it's to carry out or tolerate unlawful arrests without probable cause, to carry out or tolerate detentions and arrests based on citizens' exercise of the First Amendment right to criticize and verbally protest officers' actions, to use or tolerate excessive force, to carry out or tolerate unlawful speeches or searches on persons. So it's all this nonsense, but once again, he's got to show the challenged policy or custom. He's got to explain how that is deficient. Explain how the policy or custom caused him harm and show how it amounted to deliberate indifference. He's done the underpants gnome, underpants, question mark, profit. He's just conclusorily stated these are their unlawful practices based on this one incident, and it's just him saying he's provided no other examples that these are common practices by the LVMPD. None whatsoever. So there's the whole question mark. He has not sufficiently pled Monell claims at all. There's missing steps, but he is a moron. He does not understand the law. He does not understand litigation. He is Dunning-Kruger personified. Post-Iqbal, remember our good friend, Iqbal versus Ashcroft, a plaintiff cannot rely on conclusory factual allegations. Captain conclusory. Rather, a plaintiff must allege facts which, if true, show that the defendant actually had a constitutionally impermissible policy, practice, or custom. That's Waggy versus Spokane County, Washington, 9th Circuit, 2010. I realize Artie's corporate fiction probably isn't watching, but it's not Spokane, it's Spokane. He's done it a few times. An actionable policy or custom is demonstrated by 1. An express policy that, when enforced, causes a constitutional deprivation. That's Baxter versus Vigo County School Corporation, 7th Circuit, 1994. I realize I pronounce things wrong too, but so 2. A widespread practice that, although not authorized by written law or express municipal policy, is so permanent and well settled to constitute a custom or usage with the force of law. That's City of St. Louis versus Preprotnik. Talk about pronunciations. Supreme Court, 1988. And that was a plurality opinion. Or 3. Constitutional injury caused by a person with final policy-making authority. That's also Preprotnik. The description of a policy or custom and its relationship to the underlying constitutional violation, moreover, cannot be conclusory. It must contain specific facts. Spiller versus City of Texas City Police Department, 5th Circuit, 1997, which says existence of a policy without more is insufficient to trigger local government liability. Also, Oviatt versus Pierce, 9th Circuit, 1992. So, Captain Conclusory rides again. I need to get the Lone Ranger music to play when I do that. DeCastro has not stated a Monell claim upon which relief can be granted. 7th and 15th causes of action. In the instant case, DeCastro pleads a conclusory wish list of unconstitutional customs, policies, or practices relating to LVMPD's methods of effectuating arrests, use of force, searches and seizures, hiring and training practices, and more. I like that. A conclusory wish list. Once again, cue Lone Ranger music. Captain Conclusory rides again. However, there is no identification of a policy that, when enforced, caused the alleged constitutional violation. That's step 2, question mark. That C. Baxter versus Vigo County School Corp, 7th Circuit, 1994. Ironically, the only identification of actual policies are DeCastro's identification of policies which, when enforced, uphold and protect the constitutional rights of the citizenry, which is what I was pointing out yesterday. These don't help him. The misdemeanor arrest policy doesn't help him because that's the policy. But they followed the policy because they arrested him because they thought if they don't, he's going to follow them around the rest of their shift, which would be an ongoing obstruction. So, cite and release didn't make sense. DeCastro's conclusory assertions of an unconstitutional custom, policy, or practice are belied by his own allegations in the Second Amended Complaint, in addition to the authentic video footage in this case, which demonstrates the defendant officers applying and upholding the constitutional policies and practices identified within the Second Amended Complaint. DeCastro has failed to plead facts demonstrating any of the following. 1, an express policy that, when enforced, causes a constitutional deprivation. 2, a widespread practice that, although not authorized by written law or express municipal policy, is so permanent and well settled to constitute a custom or usage with the force of law. Or 3, constitutional injuries caused by a person with final policy-making authority. Question mark. Yet he expects $5 million profit. Therefore, DeCastro has failed to adequately plead a specific policy or practice, and DeCastro's Monell claims must be dismissed pursuant to Rule 12b-6. Irrespective of the court's decision on whether DeCastro has adequately pled a Monell claim, defendant Torrey must be dismissed as a defendant to DeCastro's Monell claim because he is not a proper party to such a claim. So basically, it's municipal liability. And last I checked, Sergeant Torrey is not a municipality. He is a municipal employee, not a municipality. You know, let me check. Neither am I. I'm not a municipality. DeCastro's state law claims fail to state a claim upon which relief can be granted. DeCastro has not stated a defamation claim upon which relief can be granted. Fourth cause of action. Boy, he's bad at defamation claims. At some point, he might learn. Nah, he's not capable. Never mind. To state a claim for defamation under Nevada law, plaintiff must allege 1, a false and defamatory statement by a defendant concerning the plaintiff. 2, an unprivileged publication to a third person. 3, fault amounting to at least negligence. And 4, actual or presumed damages. And that's Rosen versus Tarkanian, Nevada Supreme Court, 2019. I wonder if that's Jerry Tarkanian, the former UNLV basketball coach. And see also Nevada Revised Statute, Section 200.510, Section 1, defining libel. So I would actually, he should be arguing the heightened standard for a public person for I've been going too long. My brain, I'm having a brain fart. But either way, it should require defamation per se, basically actual malice. You get what I'm saying. We've talked about defamation enough, but like I said, it's late. With respect to a claim of defamation arising from a police report, such an instrument may form the basis of such a claim. However, there must be a specific statement contained in the police report that plaintiff states are false. Sykes versus LVMPD, District of Nevada, 2021. Here, DeCastro alleges that the defendant officers shared false police reports with third parties. DeCastro's alleging of legal conclusions intended to recite the elements of a defamation claim is not sufficient to state a claim under Rule 12b-6. Captain Conclusory rides again. Hi-ho Silver. Hi-ho Charlie away. Do we need to look at Twombly and Iqbal? Bare recitals of the elements of a cause of action are not sufficiently pled. Him saying, these are the elements of defamation, therefore I win. No, you have to plead facts. In addition, the authentic video evidence, as well as other allegations in DeCastro's Second Amended Complaint about the statements within the police report, demonstrate that the police reports do not contain any false information. Moreover, DeCastro fails to assert that any defendant published the report concerning the subject incident to a third person in the absence of privilege. In the absence of a false and defamatory statement and an unprivileged publication, DeCastro fails to state a defamation claim. Simply putting in a police report as a police officer about what you did, that's not publishing, and it's privileged. It's your, and they didn't publish it. It was requested as a public record. That's not Officer Bork publishing anything. So DeCastro, next up, DeCastro has not stated a battery claim upon which relief can be granted. So our boy done fucked up. Remember, in the first amended complaint, because he didn't incorporate the video by reference, and he managed to plead enough to survive a motion to dismiss by saying, they punched me in the nuts. They didn't even move to dismiss the battery claim, but now they are. This district has long recognized that the standard for battery by a police officer under Nevada law is the same as under 42 U.S.C. Section 1983 claims. See E.G. Ramirez versus City of Reno, District of Nevada, 1996, which says the standard for common law assault and battery by a police officer thus mirrors the federal civil rights law standard. Liability attaches at the point at which the level of force used by a peace officer exceeds that which is objectively reasonable under the circumstances. Because DeCastro has failed to state a viable claim for excessive force under Section 1983, he has also failed to state a claim upon which relief can be granted for battery. Next up, DeCastro has not stated a negligence claim upon which relief can be granted. 11th cause of action. DeCastro's negligence claim has been dismissed with prejudice as to all theories besides his theory of excessive force. A claim for negligence requires that the plaintiff satisfy 4 elements. 1, an existence duty of care. 2, breach of that duty. 3, legal causation. And 4, damages. And that's Turner versus Mandalay Sports Entertainment, LLC, Nevada Supreme Court, 2008. And once again, I am a 2-year-old, and so I have to giggle about the breach of duty and how that causes damage to underpants. Sorry, I had to. A plaintiff's negligence claim cannot be based on an intentional act. See Restatement of Torts, Section 282, 1965, Comment D, which states that negligence excludes conduct which creates liability because of the actor's intention to invade a legally protected interest of the person injured or a third party. So basically what that's saying is, hey, if it's an intentional act, it's not negligence. If you injure someone and it's unintentional, then that's negligence. But if you intentionally did it, that's battery. There's a difference. Consequently, as a matter of law, there is no cause of action against a law enforcement officer for a negligent, unjustified use of excessive force. See City of Miami versus Sanders, Florida District Court of Appeals, 1996, which says, hence, we come to the inescapable conclusion that it is not possible to have a cause of action for negligent use of excessive force because there is no such thing as the negligent commission of an intentional tort. And also Ryan versus Napier, Arizona 2018, where a plaintiff cannot assert a negligence claim based solely on an officer's intentional use of physical force, because there is no cognizable claim for negligent use of intentionally inflicted force. See, that when it comes to the in criminal law we call it mens rea, but the in civil it's intent, and so there's different levels of the intent element, and intentionally is higher, negligent is lower. It's and they are by definition different. And that last one was, or no, the next one is Liberty versus City of Scottsdale, 9th Circuit 2020, which applied Napier, which was an Arizona Supreme Court case, to Arizona wrongful death actions. So basically, procedurally, in 2018, we had an Arizona Supreme Court case, Napier, and then in 2020, the 9th Circuit applied that to Arizona cases for federal court, but that's still, even though it's a 9th Circuit decision, it's not binding on Nevada courts because it's interpreting Arizona case law, Arizona state level case law, Arizona statutes. So it's not binding it precedent for Nevada, even though they're both in the 9th Circuit. But it's persuasive, and it could, in other cases, be extended to the entire 9th Circuit or to all 9th Circuit jurisdictions that don't have case law on it or don't have statutory rules on negligence. So, and then next up, Scales versus District of Columbia, DC 2009, which says, if in a case involving the intentional use of force by police officers, a negligence count is to be submitted to the jury, that negligence must be distinctly pled and based upon at least one factual scenario that presents an aspect of negligence apart from the use of excessive force itself and violative of a distinct standard of care. So what that's saying is, well, there can be both a negligence claim and an intentional tort claim for excessive force, but that they have to be from two separate parts of the incident at hand, two separate reasons. So it might be, they accidentally elbowed him, so that would be unintentional negligence, and then they punched him in the nuts. That would be intentional. Therefore, in a police officer excessive force case, a plaintiff can only have a valid negligence claim if the plaintiff establishes negligence divorced from the actual force. Here, DeCastro's negligence claim is based entirely upon officers' intentional use of force and, therefore, must be dismissed. DeCastro has pled no additional facts suggesting any other legally owed duty that the officers allegedly violated. Next up, DeCastro has not stated a civil conspiracy claim upon which relief can be granted. 13th cause of action. Once again, RICO is the legal equivalent of lupus in-house. DeCastro's Second Amended Complaint alleges a claim for civil conspiracy based on a theory that the defendant officers agreed to violate his civil rights, that they acted according to a common plan and committed overt acts in furtherance of the conspiracy. In order to state a claim for civil conspiracy in Nevada, a plaintiff must allege two prongs. One, two or more persons acting in concert, intending to accomplish an unlawful objective for the purpose of harming the plaintiff, and two, the plaintiff sustained damages as a result of that action. See Sutherland versus Gross, Nevada Supreme Court, 1989. The party alleging civil conspiracy must include detailed descriptions of the time, place, and identities of the parties involved in the conspiracy. That's Brown versus Keller, Nevada Supreme Court, 1981. Here, DeCastro states in a conclusory fashion that the defendant officers conspired to violate his civil rights and cause him harm. Hi-ho, Charlie! Captain Conclusory rides again. However, such a conclusory assertion does not sufficiently plead detailed descriptions regarding the conspiracy, nor that the defendant officers acted with the purpose of specifically harming DeCastro. Because DeCastro has failed to allege that the defendant intended to accomplish some unlawful objective for the purpose of harming him, he has failed to state a claim upon which relief can be granted for civil conspiracy. In addition, even if DeCastro had pled a plausible civil conspiracy claim, the claim would still fail under the intra-corporate conspiracy doctrine. In Collins versus Union Federal Savings and Loan Association, Nevada Supreme Court, 1983, the Nevada Supreme Court held that agents and employees of a corporation cannot conspire with their corporate principal or employer when they act in their official capacities on behalf of the corporation and not as individuals for their individual advantage. See also Conley's Creek Limited Partnership versus Smoky Mountain Country Club Property Owners Association, North Carolina Appeals Court, 2017, and Copperweld Corporation versus Independence Tube Corp, Supreme Court, 1984, which applies the doctrine in an antitrust context, holding that a parent corporation and its wholly owned subsidiary are incapable of conspiring under Section 1 of the Sherman Act. See also Renner versus Werderman, Nebraska Supreme Court, 1989. A corporation cannot conspire with an agent when that agent is acting within the scope of his authority. And Gray versus Marshall County Board of Educators, or Board of Education, West Virginia, Supreme Court, 1988. A corporation, as a single business entity, acts with one mind, and the unilateral acts of a corporation will not satisfy the requirement of a conspiracy. So basically, what they're arguing there is, hey, the officers can't conspire with LVMPD because they're employed by LVMPD. So, doesn't work. Next up, DeCastro has not stated an abuse of process claim upon which relief can be granted. 14th cause of action. I mean, we've seen this different context, but in Scofield versus Guillard, the TikTok psychic case, Guillard tried to countersue for abuse of process, and it was obviously dismissed because the litigation's ongoing. So you can't win an abusive process cause of action if you haven't even won the criminal case yet. It doesn't work. That's a condition precedent. DeCastro's Second Amended Complaint alleges a claim for abusive process based on his being arrested and charged with obstruction as a result of the subject incident. Under Nevada law, a plaintiff must allege two elements to state an abusive process claim. One, an ulterior purpose by the defendants other than resolving a legal dispute, and two, a willful act in the use of the legal process not proper in the regular conduct of the proceeding. That's Lamontia versus Radici, Nevada Supreme Court, 2002. However, the filing of a criminal complaint cannot be the willful act. A plaintiff must allege a willful act after filing to satisfy the second element. That's Black Salt versus McClatchy, District of Nevada, 1985, and Childs versus Selznick, Nevada Supreme Court, 2009, which notes that the mere filing of a complaint is insufficient to establish the tort of abusive process. And that's quoting Black Salt. So it's a little different than the so abusive process is a little different. Once again, I'm having a brain fart, but the abusive prosecution, I can't. I need to hurry up before I go brain dead. DeCastro's allegations fail to state a plausible claim for abusive process under Nevada law because the basis for the claim is his arrest and the filing of criminal charges against him. To state an actionable claim, DeCastro must identify a willful act after the filing of the criminal charges. The Second Amended Complaint does not allege such an act, nor does it allege that defendants used the legal process to accomplish a goal other than for what it was created. C.E.G. Donahoe versus Arpaio, our good old friend Sheriff Joe from the District of Arizona, 2019 or 2012, where they dismissed a Section 1983 abusive process claim under Arizona law, which requires the same elements as Nevada, where the plaintiffs alleged their arrests and prosecutions were improper, but they did not allege that any specific judicial process was employed for a purpose other than what it was designed. For those reasons, DeCastro has failed to state a viable claim for abusive process under Nevada law. Conclusion. Based upon the above, the defendants respectfully request that this court dismiss the claims within DeCastro's Second Amended Complaint pursuant to Rule 12b-6, or, in the alternative, grant summary judgment on DeCastro's claims in favor of defendants. Dated this 11th day of December, 2023. Markey Auerbach, signed Craig R. Anderson. And you'll notice they accomplished in 25 pages, well, that they refuted in 25 pages what Delete Laws did in 42 pages. This says 35 pages, but you'll notice, well, we've got the certificate of service, and then we have exhibits, our good friends' exhibits, and then we've got the sworn declarations. So, declaration of Sergeant Erland Torrey in support of LVMPD defendant's motion to dismiss plaintiff's Second Amended Complaint. I, Sergeant Erland Torrey, hereby declare and say, I am over the age of 18 years of age and have personal knowledge of the facts stated herein, except for those stated upon information and belief, and as to those, I believe them to be true. I am competent to testify as to the facts stated herein in a court of law, and will so testify if called upon. This declaration is brought to authenticate certain exhibits and court filings on behalf of the defendants in the case of Jose DeCastro versus LVMPD et al. I am currently a sergeant with the LVMPD. I have personal knowledge regarding the incident which is the subject of DeCastro's Second Amended Complaint. I have reviewed my body-worn camera footage that is attached to the defendant's current motion. I can confirm that it is a true, accurate, and complete copy of what my body-worn camera captured on the day of the subject incident. The footage has not been modified, edited, or otherwise changed. Although the court can go to Artie's Corporate Fiction and watch the enhanced audio version of the body camera footage. Although the court can't actually do that, but it's there. So if you haven't watched it, go watch it at Artie's Corporate Fiction. Just don't listen to how he pronounces Spokane. Pursuant to NRS 53.045, I declare under penalty of perjury under the laws of the state of Nevada that the foregoing is true and correct. Dated this 7th day of December 2023, signed Erland Torrey. So basically we're going to have the same things, authenticating all the body camera footage by the officer on whom the body camera resided. Oh, and his name really is Chadley Dingle. And we have a flash drive containing DeCastro's YouTube video, and so the exhibit was basically the same there, the notice of manual filing. But I'd like to see a declaration from Craig Anderson saying, yeah, I got this video off of DeCastro's YouTube channel. I haven't changed it at all. I'd like to see the same thing. It's not a big deal because delete laws incorporated it by reference. So frankly, the court can go to YouTube and get it. So either way, hey, we managed to finish in 2 hours and 18 minutes. So good job, everyone. I know you played a big part in that. So where do we go from here? Where do we go from here? Where do we go now? Well, I think we're waiting until Christmas. We might have a Boxing Day special. We'll see. But so I'm going to try to start on the new lawsuit tomorrow. It should be juicy. Like I said, this is actually something I only found out before starting this video, watching Runkle, that the lawsuit had been filed for a bunch of different things. But like, I've seen a number of videos from Markey talking about issues concerning false copyright strikes, potentially false copyright strikes. And I had actually been thinking, I need to go and review these videos and give my opinion as to whether they're legitimate copyright strikes or not, and kind of cover it from a legal perspective that way. And then all of a sudden it's like, oh wow, there actually is a lawsuit. So I'm going to cover that. But after that, separate video, I'll probably go over it. I hope she doesn't sue me for copyright infringement for going over, although it'll be, reacception because I'll be reviewing the purported infringers videos. But, they're a little strike happy on the copyright strikes. But, my response is basically, try me, bitch. I'm not scared of you. So, and then finally, so I'm starting another channel, and I've got several set up. I just haven't done anything with them yet. But I've started a new one, partly, I just turned 40 last month. I know I don't look it, but I just turned 40 last month. I need to be better about keeping myself in shape. I'm not in terrible shape, but I need to do better. And so I started it partly to hold myself accountable, but also, although I've been hesitant to do it, there's some pretty big channels out there from people who talk about life as an amputee, as their experiences, the hardships, the the things that aren't actually hardships, the just life. And my initial reaction is like, well, the fact that I have one leg isn't the most interesting thing about me, but at the same time, there is clearly an audience. Maybe there won't be for me, but I'm going to give it a shot, partly, like I said, sort of to hold myself accountable online in trying to be more active, get to the gym, do all that shit. Not trying to be a bodybuilder, get ripped, just be better. And then, talk about that, talk about life on one leg. And so I don't have any videos out yet. There might be one going up same day as this. We'll see. We'll see. So, but that channel is going to be called Peg Leg Fitness. See what I did there? So, if you're interested, check it out. If you're not, don't. Either way, a subscribe would help. At the very least, for some videos, you'll get to see me, prancing around in my underwear just to, yeah. So if you want to see embarrassing videos, there you go. But that's enough for now. So please like, share, subscribe this video, and I will probably see you tomorrow for the new lawsuit. So thanks for joining me. Bye-bye.